from Parker Central. This is where the magic happens, as they say in the movies, but that's about a different room. I've been moving around a lot doing these videos. This is the second video that the first one I did is how to find the dirty secret of the forward flow agreement inside a bill of sale, and sometimes bill of sale and assignment. This second video of the three-part series, and that's loose, but I will have a third part, is discovery, request to produce on assignments. And assignments, that's the lion's share of what we argue around here and the information I give to you. It's all about the assignments. I used to say that in early videos, but it truly is. And then my later videos are different nuances on assignments, where they come from, how they're titled. And this one is about your state law. No, that's not true, because your state law or case rules will define what a true assignment is. For example, in Michigan, this can sound boring, but just let me put it up there. Suzanne? So 566.32 says agreements, contracts, promises are required to be in writing and signed. That's very important. And this is in regards to the enforcement of certain documents, promises, or contracts. But in the following cases, an agreement, contract, or promise is void. So there's two kinds of voids. There's void, which means it's dead, and there's voidable, which is, it could be void, but let's take a look. So if something is void, that's what you want. And it's void unless that agreement, contract, or promise, or note or memorandum of the agreement is in writing and signed with an authorized signature. So that is so important, in writing and signed with an authorized signature, because if you're looking at a debt buyer case or any contract-based complaint, there has to be a writing and a signed by an authorized signature. I rarely see it. They'll say, and you'll see one today, Brandy Reardon, authorized. Well, why is she authorized and by whom? It should have more information, and it should be dated. In regards to 566.32, F, an assignment of things in action, whether intended as a transfer for sale, for security, or otherwise. That is the category that must be signed, must be in writing, and that is, in Michigan, referencing all assignment of things, mostly collections. So I am going to give you a test right now. The educationist instructional video is going to make this test easier, but I'll give you what you're going to be tested upon. I hope you don't mind. So Shazam, the upstart beneficiary and trustee, put that assignment up there. All right, that is the whole thing from top to bottom. That's an assignment. In this case, I do a lot of velocity work. You saw my Court of Appeals case. That was a velocity case. In each case, there's a missing assignment. For the very first time, somebody produced something showing that the trustee that always supplies the debt to velocity, but never shows how the trustee got the debt. This is the first time they've attempted to show that somebody gave something to the trustee, and then they followed what's called a motion to compel. They hate my case so much, they want to put it into arbitration, a motion to compel arbitration. So they've supplied this chain, the missing link between the original creditor, upstart, and the weird sounding trust. In this case, it's Wilmington Savings Fund Society, FSB, as trustee of Alternate Lending Holdings Trust 2. So normally there is no prior assignment in any velocity case. The first time this has happened. So the test for you is this a good assignment where the court can go, well, looks like you got the full chain of title here. So if it's not up there, let me put it up again. Look at that. It's from top to bottom. Based on what you're about to learn, why is this not a good assignment? Or maybe you think it is. So let's put up what we look for in assignments so that they're not void. So Shazam, And we identify the parties, the assigner or the assignee, obviously. Boy, you'd be surprised on that one. And I'm going to show you one. Anyway, so identification of the debt. This is a big, big gray area, and I don't think it needs to be gray at all. If the identification of the debt is not inside that pool of accounts, of receivables, of indebtedness, and it's not just they get to slap a piece of paper on and say, here's the data form, because that thing's got to be signed, and there has to be a connection. So let's say they attach a piece of paper, which is generally all assignments that don't identify your specific debt. They then attach a data form with your name and address and some information saying, see, it has to have a connection, that extra piece of paper, to the assignment. And there is I've never seen it where it's signed and notarized and someone says, this belongs to that. And courts will see the extra piece of paper and they themselves will go, see, well, it's got to be in the assignment. The language of the transfer, meaning the account name, number, your thing is being assigned. It's no different than if you sell a car. You're not vague on you don't put the VIN, you don't sign. You have to put the whole thing or you can't register that car or sell it again. So the clear wording of an assignment must transfer all rights, title, and interest. It can't be vague. It can't be blanket language. See every single assignment that is put before me in the last 20 or 30 years. There must be an effective date, and that's another place you can go. You're going to see one today that says the effective date is in March, signed in April. So when does that become effective? At the effective date, does that nullify or void the signature? So there's all ways to come at this, and they provide you with so much meat that you can just chomp on. So the most important thing, and it may be a clue here as far as that test I'm giving you, signatures. The document assignment should be authorized representatives of both the assignor and the assignee. There is case law in a lot of states, and I'll show you some case law today, that says one assignment is enough. I believe the Michigan rule is must be a signature of the person to be charged, whatever that means. But there must be at least one signature. So if you have a document purporting to transfer the rights, title, and interest, even if they've identified fully the debt, there must be at least one signature for that and a date to be effective. So in order for an assignment of debt to be effective, the document must identify the specific debt, be signed, and show, as with no confusion, the obligation to be transferred or sold. So this video on assignments will keep repeating so that I have to have things repeated for me all the time before I finally get it. So do juries, and hopefully you'll get what I'm saying. There must be no confusion as to what is being transferred, how, and by whom. The effective date and the signatures. I didn't need to look at a piece of paper to say that. I've been living it. So let's take a look at some cases you can use perhaps in your state. Now, Michigan, for example, very quickly, that appeal I've been doing videos on that I did last week in front of the Michigan Court of Appeals, if I win on that, it could be groundbreaking in that there's very few cases focusing on assignment law, specifically the arguments they make. There are other states that have great state law, Virginia, Ohio, Georgia, Wisconsin, that specify if you're going to have an extra piece of paper, you got to have a signature. If you got a bill of sale, you got to have a signature, intent, what are you transferring, be specific. Michigan, I am hopeful that Court of Appeals case I went on will clean up and be the only case in Michigan that specifies the rules and roles of the assigner and the assignee and take away all the gray areas that are currently in Michigan. It'll be groundbreaking. I'm so nervous. But nerves or anxiety, I learned long ago, there's no such thing as jinxing anything. You either did a good job or you didn't. But it's okay. Nerves and anxiety can propel you to greatness. Just don't let it yourself believe that that also controls the outcome once the work is done. So let's put up these cases, blah, 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 these cases, Shazam, and that's basically saying how you find evidence of ownership of debt with bills of sales and assignments. So I've put up a Georgia, Wisconsin, a Texas, another Texas case. It's the same one. And the most famous one in Michigan, which is the Brown Bart case, that's as close as it comes to having the rules of assignment be set in stone. How it actually is helpful. There's a statute that covers all kinds of writings. It's called the Statute of Frauds. And they quote, Michigan Statute of Frauds still requires an assignment of things in action be in writing, signed with an authorized signature by the party to be charged with the agreement, contract, or promise, quoting MCL like we just did, 566.3132F. My point in boring you with that is look for your statute. So you get an assignment. I've told you many ways to attack it. Go look to see. It doesn't matter if there isn't. Sometimes your search brings enormous fruit for your labor. Sometimes it doesn't. It's not the end of the world. Deep dive somewhere else. But if you got a statute or a prescribed way, it could be case law or something showing exactly how an assignment should be, and there are many states that have that, bear in on that. That should be at the top of your answer. An assignment is under Wisconsin law. Here there is missing blah, blah, blah. There is no assignment, breaking the chain of title. So let me show you an assignment. I'm always bitching and moaning about, not bitching and moaning, I'm just trying to educate you, showing you all the bad assignments I come across. I actually found one that's not bad. 20 or 30 years of doing this, I found one. Again, as I've said before, credit unions are very open and honest generally about what they have or don't have. And I find that the attorneys are very reasonable and pragmatic with credit unions. There's an expression in the law, and it goes in other places, the acorn doesn't fall far from the tree. And lawyers generally are the same as their clients. So if you feel a certain way about the client, their attorneys kind of are the same way. It's weird. And I find that credit unions will produce the proper paperwork. They're easy to deal with, and their attorneys are very reasonable, especially here in Michigan. I don't deal with many credit unions in Florida or elsewhere, but let's stop talking. Here's the best, closest thing I've ever seen to an assignment. Shazam. It says, title and assignment, and we talked about how they'll put fancy titles to appear that they have what they don't have, but here you have the name of the company, Genesis Credit Union, passing on, assigning a transfer and setting over, whatever that means, to ReliaMax Surety Company, and an address, and they identify it as an assignee, and you have a signature from Genesis. So as far as Michigan's concerned, you've got the one assignment, assignee, you've got my client, which I've erased, and it's pretty close. But debt collectors are debt collectors, right? So this is a credit union doing the right thing, and then the debt collector came along and bought it, or debt buyer. And so now let's see how they screwed it up. Shazam. Now they call it an assignment and bill of sale. So you saw before that ReliaMax Surety Company bought the debt. So the next assignment is ReliaMax, called the seller, as you can see up there, but no company name. For example, if I'm General Motors, I'm not General Motors Finance LLC. The corporation structure or limited liability structure, there's no blurring of the lines. It's each has a separate corporate personality and entity and employees and everything. So just calling it ReliaMax is not the way to go here. That's not ReliaMax Surety Company. And also, this is Security Credit Service saying they purchased something. As in that first paragraph, this is based upon the assignment and bill of sale, in effect, blah, 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 under the provisions of their agreement. You know, that forward flow agreement, so where's that? And they've signed it, and I don't know, it says ReliaMax. with a squiggle and by a special deputy liquidator. I did not know what that meant, so I researched and found out that Reliamax Surety Company went belly up. And as they're going belly up, this gentleman appeared to be just signing things over to places, but there's no description, no discussion of what specifically is being assigned. It's Reliamax as opposed to Reliamax Surety Company. Even Upstart calls itself Upstart, and that's, I think, out of Ohio, but they're actually based out of Utah and California, and they're Upstart Network Inc. It makes a difference. So you don't have proper assignment here. It's missing, there's a confusion as to what is being passed. It's not my client's debt. And they refer to an Exhibit A that does not exist as usual. So let's look at another assignment, Shazam. And that's from Spring Oaks Capital SPV LLC as a purchaser, and Spring Oaks Capital LLC pursuant to that purchase agreement again that's not attached. If you go down a bit, the cutoff date is March 31st. The signature is well beyond that. There is a confusion there. It was pertaining to a First National Bank of Ohio debt that was just as unclear as to what was being passed. Do I have it here? I don't. So, but look at the bottom of that. Schedule A, First National Bank of Omaha Funding Portfolio, April 2022, a tranche. So if the cutoff date is March 31st, what is in the Schedule A that is referred to if it's an April 2022 after March 31st, 2022? In other words, that tranche should be dated a lot earlier. But the important thing is, a tranche is reflective of what National Bank of Omaha did with the debt, which is securitize it. That's language of securitization. So they can, in this assignment, they did not really identify anything. They added an assignment, which if you go look at my Smelly Socks video, that's a great video examining how bad this SPV, Spring Oaks Capital SPV LLC, screwed this up by adding a affidavit, which really made things bad for it. Let me just put up another one. This is a very common one for you, Shazam, and that's the Citibank. I always see, and you see Brandy Reardon has signed it as an authorized party by whom without a date. And again, it's subject to the terms and conditions of master purchase sale agreement. Again, let's put up the video for my last part one, examining forward flow agreements. Shazam, that was the first dirty little secret. And that is what you should key on when you're learning about how to take out bill of sales and or assignments. That was the dirty secret about they do not want you to have the forward flow agreement. Let's get rid of that. Okay, so I'll show you another quick one. Shazam, Exhibit A, bill of sale and assignment, phony name. Shazam, again, the purchase sale agreement. It's signed by a servicer and attorney in fact, with no identification of who that is. It is dated. We don't know if they're authorized, but they are a senior director of strategy operations of something. But again, there's nothing specific to the debt, the client, the account number, and they are transferring, this is all related receivable, judgments, evidences of debt in Schedule 1. Schedule 1 isn't supplied. So that's what you have to look for in assignments. So let's get back to our test. Let's put up the testing document, Shazam. And did we discover why this thing fails? This is top to bottom. So there's no identification of the client's debt, but the lethal thing here is, and as I presented to the court in response to the motion to compel my client into arbitration because they claim they own the debt, there's no signatures. And interestingly, every assignment, certificate of loan sale, whatever it is in the case, has a signature of Upstart or Cross River Bank. and suddenly, for the first time in a long time, they show up with this missing link that's been the missing link since I started doing this. How does it not have a signature when the others do? So I point all that out. I point out Michigan law, like I told you, it says you have to have an authorized signature. A lot of times the debt buyer will file a motion against me saying, but we have a signature, and there is a signature. But then you go deeper and you go, is that the authorized signature? It isn't petty. It is part of the law. The law shall be followed, not maybe. The political environment being what it is. And by the way, the political environment may be just the equilibrium of the whole thing. Maybe we went too far one way and now we're going the other way, but we're really always going to be centered, and that's a democracy. So I think there's always going to exist the rule of law. What that means is words matter. So if it says, well, you might want to put a signature, I don't know, if you're not doing anything, it doesn't say that. It shall be an authorized signature. So this is no lie, this happens. They'll quote the statute to me and say, this case said you should have a signature. And they'll drop the word authorized. And that's my stupid brain going, why would they do that? Because the guy isn't authorized. So you look for that stuff. They open themselves up to analysis because they try to make the law what it isn't against you. So in this video, I hope it doesn't be too boring. I've tested you on assignments. I presented you how to look at an assignment. It's quite easy, actually. It's just got to have a certain couple of things. Attached to the video on my website, killdebt.com, will be request to produce, because that's really the purpose of this video, is it to provide you the means of what to ask for in discovery. I'll give you a request to produce. I'll give you a cheat sheet, a fill-in-the-blank cheat sheet that says what you look for in an assignment, and if it's missing, check off the box, and you can include that in your counter affidavit. I'll add a counter affidavit for you. Couple of these bills of sale so you can test yourself, and hopefully that's enough. Provide comments if you need more videos, or hey, attaboy if we did good. And I try to do good for you. I hope I'm trying to do, I don't know what I'm doing half the time, but YouTube seems to love it if you're kind of real and from different areas. So you see me in the car, you see me stuck in a dungeon with a big snowstorm in Michigan, and now this is the Parker Central here. So if you have any questions or need any more videos similar to this, the next video is going to be part 3, how to look at affidavits. That case I was telling you about with the missing link that they filled in with this tested document, they provided an affidavit that said, hey, we own this. Just look at that bill of sale I gave you. See? And again, I can't emphasize this enough. When they offer more stuff to prove what they can't prove because it's such pretzel litigation with the securitization of it all, their foot goes deeper in the muck, if you will. And they have a sworn affidavit that says, see, we own it. So you go to the thing, and it shows clearly it violates Michigan law. That came out of Ohio, so maybe they didn't know Michigan law. Most of the times, these affidavits are written by attorneys, and then the guy just signs off. And in this case, they did sign off on a separate piece of paper, but attached it to the affidavit like it was all whole. I'm sure it was. It just so happens the actual piece of paper said 2/16, even though the document was supposedly signed in January 30th, I think, 2025. But I digress. So when they give you more stuff, they give you more ways to knock them out. So knock out this video, and I hope it brought you happiness as far as seeing that there's tons of light at the end of the tunnel. And go get them. Thank you very much.